Breaking news. South African politics has taken another dramatic turn after the Western Cape High Court granted an interdict stopping the impeachment inquiry into President Cyril Ramaphosa. The court's decision means the inquiry will be put on hold for now, giving the president temporary relief as the legal battle continues. This is a significant development because the impeachment process has been one of the most closely watched political issues in the country. Supporters of President Ramaphosa are likely to welcome the ruling, arguing that the court should first deal with the legal questions before Parliament moves ahead. However, critics believe the decision only delays accountability and that the inquiry should continue without further interruptions. The ruling does not end the matter.
Given the urgency of the matter, there are three judgments. The first judgment concludes, for reasons set out therein, that the President has not made out a case for an interim interdict. It proposes that the application be dismissed. The second judgment concludes that the President has made out a case for an interim interdict for the reasons set out in that judgment. It proposes that an interdict of a limited duration be granted. The third judgment concurs with the second judgment.
It simply pauses the impeachment inquiry while the courts consider the issues before them. South Africans can therefore expect more legal and political battles in the coming weeks. What do you think about this latest court decision? Should the impeachment inquiry remain on hold, or should it continue? Share your thoughts in the comments below, and don't forget to like, subscribe, and turn on notifications for more breaking news updates.
The second judgment is the majority judgment. In the result, the following order is made. 1. Pending the determination by this court of the applicant's review under case number 2026/119192, the first and second respondents are interdicted from proceeding with the public impeachment hearings in terms of Rule 129(m) of the National Assembly rules. 2. The cost of the application shall stand over for determination by the court which hears the review. The judgment will be made available on case lines and SAFLI shortly after we adjourn this court.
Thank you, Mr. Sami.
May I please report, my Lord, my surname is Vilankulo and I'm appearing for the 6th and 7th respondent.
Thank you. This matter was argued before us last week over a period of 2 days, and we reserved a judgment until today. This court has carefully considered the weighty arguments advanced by the parties in the limited time available given the urgency of the matter. There are three judgments. The first judgment concludes, for reasons set out therein, that the President has not made out a case for an interim interdict. It proposes that the application be dismissed. The second judgment concludes that the President has made out a case for an interim interdict for the reasons set out in that judgment. It proposes that an interdict of a limited duration be granted. The third judgment concurs with the second judgment. The second judgment is the majority judgment. In the result, the following order is made. 1. Pending the determination by this court of the applicant's review under case number 2026/119192, the first and second respondents are interdicted from proceeding with the public impeachment hearings in terms of Rule 129(m) of the National Assembly rules. 2. the cost of the application shall stand over for determination by the court which hears the review. The judgment will be made available on case lines and SAFLI shortly after we adjourn this court. That is our judgment, and we will then adjourn. Court adjourns.
This one. This one. What is it?
President Cyril Ramaphosa will find out today if his urgent bid to halt the parliamentary impeachment process against him has succeeded. The Western Cape High Court is set to hand down its judgment today, and that's after hearing extensive arguments on the matter last week.
Ramaphosa wants the inquiry stopped from going ahead with its work until the same court rules on his application to set aside a Section 89 report that found that he had a case to answer. Opposition parties are baying for the president's blood. They want him sacked for his handling of the theft of large amounts of foreign currency from his Limpopo Palapala farm in 2020. Zoleka Kodashe, live for us from the mother city and outside court. Zoleka, a lot is tested here, and also the extent to which the president can exercise his rights, but also whether the president can use the judiciary to halt or delay parliamentary oversight work. So that separation of powers issue also front and center.
Iman, and in fact that is according to the outer test, where the president needs to demonstrate the exceptional circumstances in this instance in which he seeks to interdict the work of the impeachment committee. But of course, there's not only the outer test, he also needs to satisfy the interdict test. And one of the things that the president needs to demonstrate is that the balance of convenience is in his favor. And what the balance of convenience essentially is the court weighing the possible irreparable harm that may be suffered by the sitting head of state, as opposed to the potential prejudice that may be suffered not only by the impeachment committee but also by Parliament as a whole, in that it will not then be able to give effect to its constitutional mandate of holding the executive accountable. So that's what the court will be dealing with today, that balance of convenience, and whether the president demonstrated that in fact the balance of convenience is in his favor. Not only that, he also needed to demonstrate that there is a prima facie right that he seeks to protect, but also that he will suffer irreparable harm in the event that the impeachment proceedings continue without the validity of the Section 89 independent panel report being determined. Of course, we know that that particular report or that application will be heard in the review court of the Western Cape High Court in September. And so what the president essentially says, in so far as it relates to the potential irreparable harm that he may suffer, is that he will be hauled to account before the impeachment committee in an instance in which the validity of the report has not been determined, and that report is essentially the foundational document of the impeachment committee, and he says that it is flawed. And the reason why he says that, Iman, is because he says that they used the Section 89 independent panel, used the incorrect threshold in finding that he had a prima facie case to answer. And the reason why he says that is that essentially, according to the rules of the National Assembly, particularly Rule 129A, says that the Speaker must satisfy herself that when a Member of Parliament presents a motion before her or before the National National Assembly that they have adequately demonstrated that there's a prima facie case for which the president needs to answer. However, when you look at Rule 129G, that then says that there must be sufficient evidence that would warrant or trigger the impeachment process. However, the president says this document is flawed and he cannot be subjected to a process in which he needs to account on a flawed foundational document, and he will suffer irreparable harm. But let's just take a listen to what the respondents had to say in relation to that.
Interim interdict. And so to the extent the president invokes his right to protect the integrity of the review application, the argument stands to be dismissed in equal measure. And the president also suggests that what he's concerned about is the embarrassment and ultimately his reputation that stems or could stem, speculative, I must underscore, that could embarrass him and cause him reputational harm. Well, then if that's the case, then the president ought to have reviewed the report as and when it came out. Because conceivably, the oral evidence that will be led in the impeachment committee is that which is in the report. And the report has been in the public domain for at least 4 years now. So it's not so much the president is concerned about, it's not so much the reputational harm evidently that he's concerned about. He's concerned about the consequence of the report, which is possible impeachment, hence we are here. There is no magic in oral evidence restating that which is written on paper in a report that he has never challenged up until this point, when the consequence of that report is potential impeachment.
So, Iman, that is some of the considerations that will be made by the court. But it is the argument of the respondents that the argument that was submission that has been advanced by the president insofar as it relates to irreparable harm in the interdict test, that he does not meet that particular test precisely because this report has been in the public domain, and that essentially what the president fears from this process is the consequence of the Section 89 independent panel report. How the court views this is something that we will find out at 10 a.m. Iman.
So, Kodashe, thank you for that update. So,
some scholars would say the law is an S. Yesterday, it would give Mukhebani a judgment of its own. And today, it gives a judgment not consistent with yesterday, but either way, there would be reasons to say, yes, it backs or it doesn't back the president. But one thing I can say for now is that both presidents, Zuma and Ramaphosa, have at least challenged and contributed to constitutional jurisprudence of South Africa. Because either way, it was never anticipated that we may find ourselves in situations like this where the Constitution is tested and redefined.
One of the biggest reactions coming from the political parties, and many of them have been consistent with this, is that they seem to have the view that the lower court has somewhat undermined what the Concord essentially came to a decision in May. Is it that simple? Is it that black and white? Or are we possibly ignoring what the ANC has had to say, that even the president himself has the right to approach the courts? Professor Tefu?
There has always been a caveat. There's always been a possibility that the decision may not go the way they wanted it to go. But the Constitutional Court, it said, in my understanding, that until it is set aside by a review, right, in the interim, you can continue with the process, but then challenge this, which is his right. And I think that's where the contention comes. And that's where I'm saying maybe even our law and our jurisprudence finds itself at an intersection whereby it must be redefined. It's not an easy way to navigate. The experts may talk their language, but somehow it is at a point where there is no universal agreement as to appropriate interpretation and what the appropriate direction should be taken.